Hi, this is a podcast on sustainability, climate, business, economy, and tech. And this is Seema Arora. I'm very pleased to welcome a return guest to this show, and we are going to continue our discussions on the Google case that is currently in the remedy phase. And my guest is none other than Dr. Greg Werden, who retired as Senior Economic Counsel at the U.S. Department of Justice in the Antitrust Division. At the Justice Department, he was involved in preparing numerous sets of enforcement guidelines and briefs in the appellate courts of the Supreme Court. He is the only Antitrust Division employee ever to have received the department's Mary C. Lawton Lifetime Service Award. And he continues to contribute through various papers and scholarship. And he has written a book titled The Foundations of Antitrust Events, Ideas, and Doctrines. So, very pleased to welcome you, Dr. Werden. And we have recorded a couple of podcasts, one on the landmark trial issued by Justice Mehta regarding Google's anti competitive behavior that led to its having a monopoly, and that was the judgment at that time. Now we are going to address specifically the remedies phase and just recap a little bit of the history of the case. In October 2020, the US Department of Justice and 11 states, AGs, sued Google for violations of Section 2 of the Sherman Act in general search and search advertising markets. And the second suit was filed in December 2020, where a coalition of 38 states filed a parallel lawsuit. Now, this has gone through, of course, various legal timelines, but there was the consolidation of the cases, and the bench trial started in September 12th, 2023, before Judge Mehta, and the closing arguments were submitted in May of 2024. The decision on liability was issued by Judge Mehta in August 2024. Google was found guilty of holding monopoly power through anti competitive behavior. And this we discussed in an earlier podcast, and I will urge the listeners to also take a look at that discussion. Now we are going to specifically discuss the remedies trial, and in this, both Google and the plaintiffs have suggested a course of remedies, and the final judgment on this should be issued anytime next week or the weeks after. So, before that happens, I want to take this case and discuss all the pieces that are important going forward. So, very pleased to have you, Dr. Werden, and I really appreciate every time you're on the show, I become 100x smarter. So, please take it from me.
Okay, so we should first explain that in the middle of this year, Judge Mehta conducted a remedies hearing. So it's like a trial, but technically it's called a hearing. Many witnesses, experts, technical people. He learned a lot about AI in this hearing. We'll get to that. He issued an order, a lengthy opinion, which is not the end. He's still crossing T's and dotting I's to get the language of the decree final.
Yeah.
But he issued an order saying what he was going to do, what he wasn't going to do, and why. It's a lengthy order, over 200 pages.
Yes.
And he directed the parties to confer and propose specific wording, which they did. And now he's got their proposals. He had a little half-day hearing to talk about some of their differences. And I really do expect what's called the final judgment or decree to be issued any day now.
Okay, excellent. So, why don't we walk through this? Like, it's 220 page, whatever. What is the document called? It's a summary
Memorandum
of the
opinion.
remedies. Yeah, a summary of the remedies proposed by Google, proposed by the plaintiffs, and just going through that there's so much information that is processed, and one learns how many experts have testified. So from Sundar Pichai to Eddie Q of Apple, and all the economists. So this time there are a lot of economists testifying on behalf of Google, unlike the earlier times. Why don't we go through the remedies that have been proposed? And in this phase of the trial, for example, let's start with the three core kind of remedies. One is the structural remedies which have been proposed. That included the divestiture of Chrome and the divestiture of Android, both of which have been agreed to in principle by the court as to be too drastic recommendation. And
Yes.
so they've already kind of laid the groundwork that that is not part of this remedies trial. I mean, that's not kind of on the table as a remedy for Google. And that's a kind of a big win for Google. And we've discussed this before on why that was over the top in terms of a remedy. But why don't you walk me through just a summary, quick recap of why that kind of was agreed by the judge, even though in the earlier phase it was, came forward as a recommendation that could be made.
Sure. So the idea of a remedy in an antitrust case is where we need to start. Uh,
Yeah.
and for people who just read the newspapers, they get very confused because this is explained by reporters very badly. I assume it's
Yeah.
because they don't understand. The thing that really irritated me when Judge Mehta issued his remedy opinion is that all of the accounts that I read said that he didn't do this punishment or that punishment. Well, he couldn't. This isn't a criminal case. There are no punishments. It's not a possibility. And it's
Yes.
not just semantics. Judge Mehta cannot do anything in this case that would be construed as punitive.
Okay.
It has to be constructive.
Okay.
So he's got two things he's supposed to do here: end the unlawful conduct, and his original opinion has more or less said what unlawful conduct existed, but he's got to put a finer point on it in his final decree, and then also to restore any competition that has been lost. And of course, to do that, he has to decide, well, what competition has been lost. And he didn't do that in his original liability opinion, which I think he should have. When he broke the case into two separate phases, one liability and one remedy, I don't think he understood fully what goes in what parts.
Yeah.
And he realized this when he was writing his remedy opinion. So he went back and said, well, what remedy I should impose now depends on what competition was lost, but I didn't exactly make any findings on that before, but I made things that are kind of like that, and I'm not taking any of them back. So I didn't find that there's been a lot of loss of competition. And what the government has proposed sounds like something that only makes sense if there was a lot of loss of competition. So that's his basic logic, and although there's more, for rejecting these more drastic remedies.
Yeah.
And I want to stress how drastic the Chrome divestiture really was. And it's more than the Chrome divestiture, because not only under the government's remedy was Google required to divest Chrome, it was prohibited from introducing a new browser, which of course it could have done, but nope. The government says, we want you out of the browser business.
Oh.
And that's a big thing, because Chrome's launch and all of its improvements were pro-competitive, and the government never objected to anything that Google ever did related to Chrome. And Google's control over distribution isn't what made Chrome the world's leading browser. Its quality is what
Yeah.
made it the world's leading browser. There's a lot of very fascinating statistics and data points in Judge Mehta's opinions, although I wish there was more. I'm an economist. I always want more data. But what I'll give you right now is that even though Chrome has never been distributed on Windows devices,
Yeah.
because Microsoft completely controls that universe, 60% of all of the searches conducted on Windows devices are conducted through Chrome that users download without any advantages. In fact, thoroughly disadvantaged, because Microsoft distributes its own browser, which uses its own search engine through Windows. Nevertheless, Google search in Chrome prevails because it is well known and users like it.
Yeah.
So in a nutshell, Judge Mehta ruled two things. One, the government failed to establish the necessary causal connection between the unlawful conduct that he found, which
Yeah.
had to do with exclusive contracting, and the maintenance of monopoly, enough to justify a drastic remedy. And in addition, even if it might be justified, he doesn't like the idea of divesting Chrome at all. He says
Yeah.
it's incredibly messy and highly risky, which is correct. Chrome isn't a standalone business, it doesn't have a dedicated staff, doesn't have separate business functions. Divesting it is a problem.
Yeah.
And if you take every engineer out of Google who does any work on Chrome, they may not have any engineers left because they all do a lot
That's
of things.
integral. Yeah.
And Judge Mehta was also worried that the product would be degraded and the
Yeah.
consumers would be harmed. And his concern on the contingent divestiture of Android was very similar.
Yeah. So I have a question before all this. You talked about the bifurcation of the liability and the remedy phase. Was that something that was a choice or it could have been done simultaneously?
Oh, it absolutely could have been done simultaneously. That's the normal thing to do.
Okay. And how did that happen then? How did this decision, who
Well, the
made that?
government filed a motion, and Google said, yep, that sounds like a good idea to us. Let's do that. And the idea is pretty simple. If the government loses the liability trial, then you're done. So you don't ever
Yeah.
have to talk about remedy. So to the judge, that sounds like a good idea.
Yeah.
And because Google said it was a good idea, nobody ever told the judge there were downsides, but there are downsides.
Yeah.
I think because the case was bifurcated, the judge was not thinking about remedy at all at the liability phase. And that's a problem.
Yes.
You need to think about remedy in every minute
Yes.
of the case. What are we trying to do here is always the question in a civil case. Civil case is about relief. That's all it's about. The system doesn't allow a civil case that isn't about relief.
Yeah.
Unless you're asking the court to do something, you don't have a case for the judge to decide.
Yeah.
So the question for a judge always is, what are you asking me to do and why are you entitled to that? And here the government says, oh, we're not going to talk about what we're asking you to do until later. And I think that affected the way Judge Mehta thought about the case in an unfortunate way. And in particular, he realized when he gets to the remedy phase that the key question is what loss of competition has been shown here. And he was not at all focused on that question. And now he needs to have already decided it.
Yeah. So it is like, so in the initial phase, this idea of divestiture of Chrome and of Android, were they kind of like good ideas? But now when it actually comes to the remedy phase, you realize that that's not a good idea. Is that what is happening?
A
The
little bit.
practicality of it and the,
My suspicion is the government came up with this idea without knowing very much about how Chrome is operated in Google. If there's a nice, clean divestiture that solves a problem, then it may be a great idea. So it's a fine thing to discuss, should have been
yeah,
on the table, but what problem does it solve? I think that's where you already come into difficulty. It solves a problem that didn't ever exist. There was no problem related to Chrome. Chrome was purely pro-competitive, and the only reason the divestiture was proposed was literally to take users away from Google. And I have to ask myself, why do they want to do that?
yeah,
And the first answer I come to is they're trying to punish Google, which they're not allowed to do. And
yeah,
then fallback answer, well, they're trying to level the playing field. But they're not supposed to be trying to level the playing
yeah.
field. They're only supposed to be fixing what was broken by the unlawful conduct.
Yeah.
So the whole case presupposes that what Google did caused a massive shift of usage to Google, and there's not the slightest evidence that that's true.
Yeah.
Chrome, on the other hand, was extremely popular and caused a massive shift of usage to Google search.
So, I some of the statistics here, I mean, mentioned that Chrome was some of this data that was quoted here was the queries to Chrome are like X compared to other users, I mean, other browsers, and X compared to other browsers on the mobile space. And that again is a function of its being better quality and more innovation, and also the whole idea of how Chrome was the first in the mobile space, right, as compared to Bing.
Those statistics are not just Chrome. That's Google search. So those
Okay,
numbers include not just Chrome, but also Safari, also
okay,
Firefox,
okay.
because the Google search engine is the default and gets a lot of traffic through those browsers.
Okay, so that's the summation of all of the browsers that are relying on the Google search engine. Is that correct?
Yes.
Okay, so now in terms of this, okay, so one thing that I am hearing, and please tell me if I'm correct, is that Judge Mehta is trying to again benefit the competitors rather than fix the competitive process, because the competitive process is not broken by Google. It's more that they're looking at the space and saying, oh, you're a monopoly. That must mean that something wrong is going on. It must be anti competitive behavior. And therefore, let me try to benefit the other competitors in the space. Is that kind of the way it is coming out?
Well, yes and no. Judge Mehta is a smart guy, good judge, but um, at times he seems very confused to me. Much of what he has written in both of his opinions seems to be saying that Google's rivals lost something because of the unlawful conduct, and it mattered. He didn't put any numbers on it. He doesn't give you the slightest hint as to what these numbers might be, but he's convinced they lost something that mattered. But how? What opportunity did they ever have that Google took away from them? I don't think there was one. I think his findings show that there wasn't one. I think we'll get back to this later. And it's reinforced in his remedy opinion that he thinks that there was some real market bite of these exclusive dealing that took something that Google wasn't entitled to, but I don't see it. And he doesn't have a clear finding on it. And I don't know how he thinks it could have happened,
Yeah.
because all of Google's partners were just trying to maximize profits by promoting Google's search engine. That was the way to make money. The evidence on this is striking, and I don't think Judge Mehta really took it in the way he should have. Let me give you a few more numbers here.
Yeah.
The Firefox browser is an interesting experiment in two different ways. One is that for a while, the default was Yahoo. And when it was Yahoo, only 30% of Firefox traffic went to Yahoo.
Yeah.
It mostly went to Google. Then they switched to Google, and Google gets 80%. So making Google search engine the default has a big effect of bringing users to Google, but making somebody else's search engine the default doesn't have a big effect of bringing users to that person. Well, the result is that that person can't afford to pay very much for default status. And Mozilla did similar experiment with Bing, Microsoft's search engine. While Google was the default in Firefox, Mozilla ran a controlled experiment. It shifted the default for a tiny fraction of the users to Bing, and then, checked what their search behavior was. By day 12, only 42% of
Still.
the search volume had been retained, and it kept going down over time. And this is why Google was the preferred partner for all of these people it partnered with. Apple's the big prize here. The Safari browser originates 28% of all US search queries. That's a
Okay.
lot.
Yeah.
From Safari's inception, Google's always been the default. But Apple was willing to entertain offers. It had meetings with Microsoft. It cranked the numbers.
Yeah.
Microsoft in 2015 offered 100% of its incremental advertising revenue in order to get the Safari default. 100% wasn't even in the ball game. Judge Mehta credited analysis that was actually done by Google
Yeah.
while Google was offering 33.75% revenue share. And that
Mhm.
analysis concluded that Microsoft would have to offer 122% to match. Well, they can't afford to offer 122%. Once you get over 100%, this deal doesn't make any business sense.
Yeah.
So Google's partners partnered with Google because that was the way to make money.
Yeah.
And then they negotiated for as big a chunk of it as they could get, and they got a lot.
Yeah. So 20 billion for Apple on an annual basis, right?
Yes.
And so none of the other search engines could obviously compete with those figures. So the numbers that you are citing, were they presented in the earlier liability determination?
Yes.
It's correct. Okay. And now in the remedies phase, so we are just as you're pointing out that the starting point of this is on a shaky foundation for Judge Mehta's ruling, in the sense that there is no evidence of anti competitive behavior. It was just a matter of innovation and quality that Chrome became important, and so divestiture of Chrome doesn't make any sense. Correct?
That is basically right, but I think a lot of people would say, well, it's an oversimplification at least. And so let
Yeah.
me add Google did enter into contracts, and those contracts did say that
Exclusive.
its partners must promote
Yeah.
Google search engine in certain ways. Judge Mehta just couldn't help but think that had to matter.
Yeah.
Why are these people being paid a large amount of money to enter into these contracts if it doesn't matter?
Yeah.
And nobody made the argument that I would have made if I was Google's lawyer that, well, businessmen want to cover themselves, so they write contracts that where people guarantee that they're going to do the things that is in their interest to do
Mm-hmm.
because you know, they're paranoid
Yeah.
and they don't want the unexpected to happen. If it comes up, they want to be able to say, "Hey guys, we got a contract. What are you doing?"
Yeah.
And this is a world of innovation, so new stuff can happen constantly, and they want to get as many assurances they can about what they can control. And so they write these contracts and they negotiate them in great detail over a long period of time.
Yeah.
And I think the Judge Mehta misinterpreted these negotiations. So he sees evidence that Google's partners are constantly saying, well, I don't know about that. I might want to keep my option open on this. So can't we just say that I may do this? And can't we just say, if I do this, then this? And Google keeps saying, oh, I'd really rather not say that. I interpret this as just the way you negotiate. Google wanted assurances. Its partners were willing to give them, but they wanted payment for every assurance they gave.
Mm-hmm.
And why not? They're in it to make money.
Yeah.
So they're extracting from Google as much money as they can.
It's like a contract which is a win-win, at least for the partners.
Exactly. So basic economic theory says that you're going to have a contract kind of like the one you got. All of Google's partners were able to make the most money by partnering with Google. That's the biggest pie. You want to create the biggest pie. And then you negotiate for the biggest slice. And whether they could have got more, I don't know. In many cases, I don't know how much they got because that remains confidential.
Yeah.
But they got a pretty big slice. You know that, Apple, you've already mentioned, got up, and this information is now at least 5 years
Huh.
old,
Yeah.
got $20 billion in a year, probably much more now,
Yeah.
and its other partners, $6 billion in the same year. So
Yeah.
$26 billion its partners got
Mm-hmm.
from being good negotiators.
Yeah.
The alternative to doing business with Google wasn't going to make them a little bit less than $26 billion. It was going to make them a lot less
Lot
than
less. Yeah.
$26 billion. My
Yeah.
guess is less than half as much. And that brings us to another remedy that Judge Mehta rejected. The government proposed to ban all payments for distribution. And that's the way you get distribution. You either build your own browser and push your search engine through that, and government wanted to ban them from that, or you partner up, as Google had done, and not just Google. I already mentioned Yahoo did it.
Yeah.
Everybody who could do it was doing it. You partner up and you pay a chunk of the revenue that you get from the partnership.
Yeah.
I was about to say economic theory predicts that will happen. It's not as good at predicting what the split is going to be,
Yeah.
but you bargain over that. And they did, and Google paid a lot, and they got a lot, and everyone was happy, except Google's rivals weren't doing so well.
Yeah.
But had there been no contracts, they still would not have done very well, in my opinion, because how were they going to get this distribution? They had nothing to offer that would entice the partners into the partnership.
Yeah.
Judge Mehta is a little worried. I don't think he should be that worried, but he's a little worried that the payment ban is going to blow up because some of the partners that Google has today will decide to keep promoting Google's search engine without any
I think
payment,
payment.
because the alternative is to promote some inferior search engine, and that is going to detract from their attractiveness to customers. Like if you're a browser developer, you're Mozilla, you produce Firefox. If Firefox with the default search engine performs badly, well,
It'll be
people
out
could
of business.
change the default, or they could go away and use another browser, and Firefox doesn't want that. So they're very concerned about what browser they offer.
Yeah.
Back when Safari was new and there wasn't any money in this game, Apple partnered up with Google in a simple software license with no money changing hands because Apple wanted to offer users the best search engine. It's still the best.
Yeah.
It may not be a lot better than Bing or others, but it's better. And in the mobile
Mobile.
space, it's
Correct.
substantially better.
Yeah. Okay. So, yeah, that's excellent. I mean, this whole case, I think the sticking point again for Judge Mehta was the exclusivity of the contract. It's not just the contract, but the exclusivity of the contract. And I think that's kind of the penalizing, that's why all the remedies are kind of trying to correct for the fact that Google wanted preferential placement or just exclusive deals with the carriers, the OEMs, in terms of just that as the default kind of the search engine. Is that sufficiently established, or is it again just a matter of contracting with the best partner that they could find?
Well, I think I already mentioned that my take on this is that Judge Mehta saw exclusive dealing, thought it must be like every other instance of exclusive dealing, that Google is necessarily taking away an option that its partners would have made use of if they were allowed to. And I guess I blame Google's lawyers a little bit for not doing a good job of explaining that this case isn't like other exclusive dealing cases. It's in fact very different. Normally, and this is the textbook case and it matches the facts of leading litigated cases. Normally, distributors do best by not being exclusive. So they
Okay.
aren't.
Yeah.
You, you go to a store, they carry several brands. They don't carry all the brands, but they carry multiple brands. So if somebody wants an exclusive, they usually have to bring some pressure to bear to get it. And we have lots of examples of that happen. It isn't necessarily a bad thing.
Yeah.
Exclusivity can be very efficient, but to get it, you have to overcome the fact that the distributor doesn't really want to do business that way. And so what it takes is coercion of some kind. You're at least threatening to take away a profit opportunity, like
Yeah.
not do business at all with that person unless they go exclusive. So that's how you get exclusives. Well, that isn't what happened here. Nothing like that
Yeah.
happened. The distributors here wanted to go exclusive. There's only one default.
Yeah.
Splitting that up is technically
It's
possible,
not.
but not something anybody was interested in doing. And so it's not like a normal exclusive dealing case. I think I spent years thinking of the best analogy. The best one I can come up with, which is not ideal, is gas stations.
Yeah.
So everybody's familiar with gas stations. And although the world of gas stations is much more complicated than what I'm going to describe, imagine all the gas stations are independently owned and operated businesses. But they don't want to carry every brand of gasoline. They don't even want
Yeah.
to carry two brands of gasoline. That's impractical. Are you going to have double the normal number of pumps and double the normal number of tanks? That's a problem. It's going to add a lot to cost, not much benefit from it. So the easy thing to do is sell one brand of gasoline. So you talk to the different oil companies and find out who will give you the best terms. And then you go with them and you put up their sign and you put up pumps with their name on them and you become an exclusive distributor of one brand of gasoline. And that actually happened way back when in the history of the
Yeah.
gas industry.
Yeah.
And the Federal Trade Commission sued them and lost. So I
Okay.
think it's a lot like that.
Yeah.
And so this and there are other antitrust cases that are like that. And Google's lawyers did point this out to Judge Mehta. And Judge Mehta, I think, took the wrong thing away from those cases. And
Yeah.
again, maybe it's because Google's lawyers didn't stress what should be taken away from those cases, but it's
Mhm.
very simple.
Yeah.
In those cases, the defendants didn't do anything wrong. They just made the best offer and it was
Yeah.
accepted. They
So
didn't
it is.
say, if you don't deal
Yeah.
with me exclusively, then you can't deal with me at all.
Okay, so yeah, I think that example is very instructive. And also, when you said about Bing trying to make that same deal and it didn't match up to what, Chrome could provide, I think that's, yeah. So it's a matter of stressing the legalities or the legal cases that happened already that might have been suggested by Google lawyers to make the case more emphatic. I think that's a valid point. But now, when we talk about the payments, so in the remedy phase, the payments ban is not an option. Judge Mehta has recognized that. And it's very interesting of why that is not the case, that why should there not be a payments ban? Because in the absence of payments, now it is being suggested that well, Mozilla will go out of business if it doesn't receive payments. Apple, in fact, Apple, such a successful company, says loss of 20 billion will impact our ability to innovate on other products and services. And so the list goes on and on to suggest that wow, without the payments, Google might become even more. It will have deeper pockets because guess what? Chrome will still be the default, or the search engine would be still the default. And on top of it, now Google is not making any payments. Is that a correct
Well,
understanding?
that's a possibility. I don't think it's the most likely one. I think that the most likely one is that everyone in the browser space will partner with Microsoft because they need the money. And although they can only get maybe half as much from Microsoft, half
Yeah,
as much is a lot. It might be enough to keep Mozilla in business.
yeah,
Half of 20 billion is 10 billion. Apple can do something with 10 billion. They're still going to be 10 billion short. That's going to matter. But
yeah,
I think they'll take the 10 billion. The government suggestion was that they would develop their own search engine. In the Remedies trial, Apple says, yeah,
not really.
that's
Yeah,
not very likely to happen.
yeah,
It's a very expensive, risky proposition. We're not that keen on taking it on.
yeah,
They might. You don't know what they're going to do. But what's the easy course of action? The obvious course of action. It is to make a deal with Microsoft. Now, Microsoft probably will offer decent terms because they have the potential to become the dominant search engine with this remedy, with the payment ban, with kicking uh, Google completely out of the browser space. Microsoft has a huge upside here. What's
yeah,
going to happen in the Android world is less clear. There, I think that Google's partners are apt to do a lot of what they were doing under contract, but maybe not. They're certainly going to be open to offers to distribute other software instead of the Google search widget and Chrome. They're businesses, they're in it for the money.
yeah,
But the Android universe is superintended by Google, not making a deal to promote Google's browser and search engine would create a tension, might lead to the decline of the ecosystem. And so all the participants in there have a lot to lose.
yeah. So, yeah. I mean, so I thought that the idea of, or what, okay, let to put the in terms of the remedy, the payments ban, that there will be no payments ban, which means the payments can continue, is sort of agreed to by this judgment, which means that basically the status quo in terms of Apple will continue to receive payments from Google. And that, because even I thought that the smaller browsers like Mozilla and all testified that if we were not to get the payments that Google would normally give us, then we would be in a lot of trouble. And agreed, there are other competitors, but those payments will not just match up with what we are currently receiving. And so, in the judgment, the court agrees that that would really impinge the process, in the sense it would pose more harm, because Google will still continue and it would be a lot better off because it might still be the default. Its search engine will still be the default, and on top of it, it would not have to make any payments. So it's the law of unintended consequences that the remedy would be harsher for the competitive process.
Yeah,
Is that a fair
yes.
takeaway for
So
the?
the most drastic remedies aren't going to happen. Judge Med
Yeah.
has already decided that.
Yeah. So then, okay, so on that account, Google is still going to have that same ecosystem. But what is the next kind of remedy in this case? I mean, just coming to, I mean, we'll come to what Google is recommending for the remedy phase. But what is the next remedy on the table? There are a lot of the fact that, I don't know, I'm not using the right words, but the fact that Judge Mehta thinks that there has to be some kind of remedy for the exclusivity, right? We're not agreeing with it, but the exclusivity deals that then led to scale advantage for Google, that somehow has to be undone. That harm has to be undone. And therefore, the recommendations of data sharing, with the other competitors for Google, what is the kind of assessment on those remedies?
Judge Mehta distinguished between a structural remedy,
And of
such as divestiture of Chrome, and what he termed a robust behavioral remedy, a term he coined. It's
yeah,
never been used before.
okay,
He says, well, the government showing on lost competition doesn't justify a structural remedy, but these robust behavioral remedies, they're different. They don't
okay,
require as much of a justification.
okay,
And I think he's completely wrong about that. He's wrong about what's a structural remedy. In my view, data sharing clearly is a structural remedy. It
yeah,
directly builds up the capabilities of Google's rivals. That's the whole point. In
yeah,
this way, it directly alters market structure. That makes it a structural remedy.
yeah,
I think that Judge Mehta has equated market structure and market shares. I think
okay,
that because I work with lawyers for decades and they did that all the time. But that's wrong. That's not how economics understands the term market
okay,
structure. Market structure consists of certain background conditions that affect the ease of entry and the allocation of tangible and intangible assets among the market participants. In model building, these are the foundational elements of a model.
mm-hmm,
And a structural remedy is something that alters these foundational elements, like
yeah,
reallocating the assets. And that's what
yeah,
Judge Med is doing.
yeah,
Giving people data that is considered essential to compete is obviously giving
exactly,
them important assets.
yes,
So I think he's wrong about this, and I think the Court of Appeals will think he's wrong about this. He's not, however, going to require Google to give up as much data as the government asked. So Google has to give up in this remedy what it got from crawling the web and what it got from logging user queries, but not anything that was derivative from that data. So all the things that Google has done to be able to do a search in
yeah,
nanoseconds when you make a query, they don't have to give up.
yeah,
They also don't have to give up what they call the knowledge graph, term I'd
yeah,
never heard before
yeah,
the remedy hearing, but I see it every day. This is the database of 5 billion people, places, and things that Google draws on to answer a lot of queries off to the right on your screen, frequently on the right. It's not always on the right.
yeah,
It depends what you're searching for. Like If you type in restaurants near me, it will bring up a list on the left and a map on the right of restaurants near me. That's the knowledge graph. And then if you click on a restaurant, it'll give you the hours and other information. That's the knowledge graph.
Yeah.
If you type in my name, you get a little something, not much.
Yeah.
I'm a really unimportant item in the knowledge graph, but I'm there. So I'm in the 5 billion. I made that cut. I'm in the top 5 billion. So the other robust behavioral remedy is syndication services. Now, that's a term that's probably meaningless to many listeners, but here what it means is that Google will enter into a contract with a rival search engine to do some of that search engine searches. So certain queries will be instantaneously handed off to Google. Google will
Yeah.
return to that search engine the organic search results, including the ads that would normally be returned had it been a Google search. And then those can be displayed or not, whatever they choose to do, by the other search engine through whatever browser or device they're working through. Although there'll be limits on how long you can do that and how much of your volume can go through that. And the
Yeah.
final numbers on that, Judge Mehta wants to be determined by a technical committee sometime in the future. My understanding is this, because of the way Judge Mehta wants to do this, it's very doable. And
Yeah.
Google, I don't think, is terribly upset about doing it, but they get paid. And I'm not so sure anybody's going to want to pay them.
So for this, they get a commercial, or at some point they said at marginal cost it has to provide this data, but for this it's a commercial rate.
Right. The government want them to have to do it at marginal cost, and Judge Mehta said no, they do it at commercial rate.
Yeah.
I
And
don't
how many?
think that
Yeah.
Google has ever done this in the United States with anyone, but it has done it outside the United States. So Judge Mehta kind of thinks determining commercial rate will not be that hard. I don't
Mm-hmm.
know. It might be very hard. They might have to negotiate. This certainly isn't something the technical committee is designed to resolve. It's not a technical question,
Yeah.
and it's not something courts should be dealing with.
Mm-hmm.
So it's not a trivial problem. But if Google wants to offer this service, they will find a rate people are willing to pay.
Yeah.
This is how business works. The
And
only
this would
problem
be,
is if Google didn't want to do this service and
yeah.
then would offer a rate that nobody wanted to pay, then the court would have to try to do something about that. But the problem is the data sharing, which has to be done at marginal cost,
Yeah.
which might be a big number. This is a lot of data. I'm not sure how you get it. It's not going to be on a thumb drive.
Yeah. And how, and they'll calculate and then there'll be a negotiation with the court or no? Just no, period. It's marginal cost
I
for Google. Yeah.
I don't think it's going to be hard to figure out what the marginal
Yeah.
cost is. And I don't run these businesses. I don't work in them. I don't know a lot about how they work. But I can imagine it will take millions of dollars worth of engineers' time to figure out how to do this.
Yeah.
And then the doing will be more of a hardware thing. How are you going to carry away all this data?
Yeah. So, data sharing, again, this is what the judge wants them to do. I mean, the plaintiffs want them to do, correct? And the judge is determining, well, this is feasible, this makes sense or not, or based on all the testimonies. But, you mentioned the two data sources. One was just kind of the search index data using it's at the back of all this is Judge Mehta's belief, or I don't know, judgment that somehow the scale advantage has to be undone for Google. And therefore, there are some data sources which Google has been advantaged just because of its scale. And so there was this, okay, so first the search index data, which is where Google basically crawls on websites and collects information on how reliable they are. There's like a spam score. Then there is also, of course, the reliability and the quality score, which they're not required to reveal. It's more kind of just the description of the sites and, whether there's harmful material on those sites. So those kind of things or data is what Google is required to disclose. And also there's discussion of the frequency of disclosures. Is it like a one time or is it a few times? Because every time Google does that. I don't know again what is the cost of giving all this data. Google has, and in terms of access to the user data, Google has said, well, it's going to be very difficult to anonymize the data because people could be making searches in a small town, and it's very easy to then figure out if they're kind of searching for rare disease. And so the Google has objected on grounds of the costs of doing this in an anonymized manner. So all these are kind of discussions that are happening. Makes me think that Google lawyers are okay with having different contingencies, correct? I mean, they're presenting their viewpoints.
Well, certainly can't speak for Google or Google's lawyers. I don't think they were happy with any of the data sharing.
Yeah.
Some is much more objectionable than others. Whether Judge Mehta has sorted out all the privacy concerns, I'm not sure. Not really a privacy guy.
Yeah.
Um, the expert testimony wasn't very reassuring. The plaintiff's expert says all this can be worked out. Okay, that doesn't answer any of the questions.
Yeah.
And some issues may be left for the technical committee. I don't think we're going to know some of the details till the actual remedial order comes out.
Yeah.
We know basically what has to be shared, and Judge Mehta is attuned to the privacy concerns here, and I'm
So,
sure the technical committee will be too if if they're not completely resolved, and
yeah.
some are left to the technical committee. The whole premise, though, I want to come back to the premise that somehow Google got a scale advantage through exclusive dealing, I think is faulty. If you go back to when the first of the exclusive contracts was entered into, Google already had a tremendous scale advantage.
Yeah.
One thing that trial didn't come close to resolving is what scale advantage is meaningful and what scale advantage is decisive. So, has Google all along had a scale advantage that was so overwhelming that they could never be competed with? Maybe. We don't have a yes or no answer to that. If the
Yeah.
answer is yes, then the exclusive contracts are irrelevant, absolutely irrelevant. So what is the evidence that no, it's not that big of an advantage, but every little bit matters? Well, it's all very fuzzy.
Yeah.
And I didn't try to figure it all out because it was clear to me that nobody knew the answers.
Yeah.
What Google was trying to argue was that their scale advantage didn't really matter that much. And there's some evidence to support that position, to be sure. And Judge Mehta says, no, it matters. And if it doesn't matter on the normal average query, it does matter in what's called the long tail. So
Yes.
these are the low frequency queries. And anybody who's ever done a search, which is everybody,
Yeah.
understands that there are common queries and there are uncommon queries. And the very uncommon queries are the ones where Google has the biggest advantage because they do the most business. And so they get the most of these queries. And you
Yes.
learn from doing here. And so they're going to give you better results in this long tail. How important is the long tail? I don't think there's any evidence on that. Maybe
Well,
it's not really very important.
yeah.
Maybe anybody's choice of a search engine or a browser doesn't depend on it at all. Or maybe it's the most important thing.
Yeah.
It's not resolved in this case. We just don't know. But the question is that I think we have answered in this trial is how much usage did Google gain through exclusive dealing? And the answer is approximately zero. So whatever it takes to matter, it's not enough here
Yeah.
because there's simply no evidence that there was an opportunity to distribute a rival search engine that was bypassed because of the contracts. These opportunities were bypassed because they didn't make money.
Yeah.
And in the alternative universe, whatever that is, you have to assume that all of Google's partners would have tried to make money. And they wouldn't have done all these things that would have benefited Google's rivals, but wouldn't have made money.
Yeah.
So I think Judge Mehta's own findings make an absolutely convincing case that the exclusive dealing didn't matter.
Yeah. Okay. So coming back to this long tail queries, now here too, I think some evidence or was presented saying that, well, long tail queries would be highly desirable for smaller search engines if Google could share that data with what they call qualified competitors. And that excludes like OpenAI or Anthropic, but share it with qualified competitors because that will enable them to innovate and improve their search queries as well. And so that data should be disclosed. I think, I don't know if it's one time or.
Well, let me pick up on a couple of things there. First, the timing.
Yeah.
Um, Judge Mehta seems not to have made up his mind in his remedy opinion on that. The
Okay.
government says, well, I want them to do it kind of on a continuing basis. Judge Mehta
Yeah.
says, no, not going to happen.
Right. Okay.
I'm leaning more toward a one time disclosure. But he
Okay.
says, I'm not quite there. So I'm thinking maybe not just once. Well,
Yeah.
then what? He doesn't settle on something exactly, but not continuing basis.
Yeah.
So something closer to one time, which really matters. Judge Mehta is rightly concerned that to the extent Google has to give up every source of its advantage, it has no interest in continuing in this business, much less
Yeah.
innovating. You don't really want to do that, and he's not going to. Except he may make some accidents, but he's aware that this is a concern. He's acutely aware that he doesn't want to be responsible for breaking this business.
Yeah.
And so he doesn't want to take away Google's incentive to compete. Okay. So who gets the data? I wasn't sure what you were saying on that, and it's not entirely resolved. The government was pretty coy on this, I thought. When I was in the courtroom, when this question was discussed, and Judge Metis, I may not remember this right, but he asked a question like, well, I presume this does or does not include X or Y. And the
Yeah.
government said, oh, I could include that. Well, maybe not. I don't know. But yeah, it could include them, definitely.
Oh.
Could. They didn't say does, could. Judge Mehta clearly intends for the AI guys to get the data. He sees them as the future, probably for good reason, and he wants them to get a jump start from getting Google's data. And so if they want it at marginal cost, it's going to be available to them under what Judge Mehta orders. And I assume that they're going to want it. Some of them have already said they want it. Maybe they won't all go for it because they have different ideas of how they're going to do business in the future. But the ones that really want to compete with search engines are probably going to want it.
Yeah.
It's kind of a one-time offer of something that could be very valuable, so you
Very
take
well.
it.
Yeah.
And Judge Mehta was really taken with the AI revolution.
Yeah.
And I think that he probably would have ordered more extensive remedies had AI not made inroads. A big issue was how the remedy should box in or not box in Google in the AI world.
Yeah.
He's willing to let them compete because he sees a lot of competition there.
Mm-hmm.
There's certainly a lot of competitors. There's no doubt about that.
Yeah.
And even in browsing, there's a lot of action there, and a lot of action even since the close of the evidence at the remedy proceedings.
Yeah.
It's not something I really follow, but I Googled it a couple of weeks ago.
Yeah.
And I had already been reading stuff about Perplexity's Comet browser. It's
Yeah.
hot. A lot of people are
Yeah.
saying it's the way to go. Dump Chrome, it's history. So, for the first time in a long time, Google is facing a competitive threat when it did not face during any time that's relevant to this case, but it faces today.
Yeah.
What's going to become of this? Who knows? We
Yeah.
may be at an inflection point here.
Yeah.
And Judge Mehta wants to think of himself as helping at this inflection point.
Yeah. So, very interesting about the incorporation of AI in the judgment because, like, the pace of innovation that is happening is quite dramatic, and the number of competitors is also quite, it's like a free play right now. And so, there can be two ways of looking at this, and I think talked about in the case as well. One is search being appended by AI kind of development of AI and chatbots. And on the other hand, Google itself is incorporating AI in its search, like AI mode and with Gemini and so on. And so it's interesting to hear from you, like how Judge Mehta is thinking along those lines. One of the things that I was also thinking is in respect to the presentations that were made by Google, like, and I think I read also that is this kind of remedy phase also going to say, or I think Google is saying that we are not having exclusive dealings on Gemini or AI mode with the Android ecosystem. We are allowing for other placements, so it's already kind of saying, oh, we've already done this for AI, so don't touch it, leave AI alone, I think,
Yeah.
is kind of the sense I'm getting.
I kind of criticized Google's lawyers a couple of times, but I want to say that they did exactly the right thing
Yeah,
in terms of getting out in front of the remedy and proactively implementing what they had proposed. That definitely got them on
good
Judge
side.
Mehta's good side.
Yeah,
So they put their proposal out there when the government did, and then
yeah,
they acted on it.
yeah,
They already don't have exclusives. It may
exclusively.
be on a rolling basis at
Yeah.
some extent of where they are in migrating the contracts. But they are, migrating the contracts. They need some clarity on what they can do and what they can't do.
Yeah.
So they've taken a stab, and they will get more clarity in the judgment. And as a big part of it, as a user of these services, I'm more amused than using AI. So I frequently intentionally don't look at the AI result in Google
Okay.
because there's a good chance it's wrong. It's probably right. More likely than not, it's right, but there's a good
Yeah,
chance it's just wrong because
yeah,
all it's doing is it's taking what's out there on the internet and
summarizing it. Yeah,
synthesizing it.
yeah,
Well, a goodly part of what's out on the internet is wrong, or at least out to
yeah,
date.
yeah,
So, and I don't even remember what it's about, but I watched a video recently on something, and the guy said at the end, and by the way, if you ask AI the answer to this question, you get the wrong answer because AI has based its answer on this April Fool's Day post that some guy did.
yeah.
AI doesn't know it's an April Fool's Day yet. Maybe next year it'll understand you can't put any stock in the April Fool's postings.
Yeah, true. Well, yeah, and
Oh,
as
I
you
can
said,
remember what it was about. Is
yeah,
there a secret tunnel under Buckingham Palace?
and it actually said yes.
Yes, I said yes.
Oh my God, that's hilarious. Well, so yeah, so you can say, so there's still search independent and search with AI mode, which and
Yeah,
yeah, and
unlike a lot of people,
yeah,
about half of my searches are for things. Either I find it or I don't find it.
yeah.
It's not information. I want a thing, a
Okay,
document, a thing to buy. So AI maybe can help a little, but not that much.
but not that much.
And if I have a simple question, Google frequently answers it with the knowledge graph.
Yeah, and
Or
that's
maybe I
the
find it through
access to the
Wikipedia.
yeah,
Um, and a lot of things, if I don't find it in 3 sources, I don't believe it.
yeah,
But then I've even learned you can find it in 10 sources and it's still not true because
yeah.
everybody copies everybody and they've been doing it for hundreds of years.
Yeah, so they're not independent. But Perplexity has this thing of where it says every source that they consult, I mean, they provide the information with all the source sightings, like, as if they were
And
PhD
ChatGPT
students.
does that. And I have a friend who tried to convince me. Um, and so one time he sent me something and I clicked on the sources and not really.
Yeah, it's a limited resource, sources rather. And
And
independently, I don't think you'll go there.
it's an arcane point, but there was a point of law that was relevant for my book. I won't even
Yeah,
tell you what it is.
yeah,
But about 10 different late 19th century treatises said the exact same thing. These are
yeah,
treatise writers. What do they know? And they
yeah,
all cite the same case. And for months, I couldn't find this case. Very
yeah,
hard to find this old English case,
yeah,
like from 1700. Um, And eventually I find it. And it's nothing like what anybody's portrayed it to be. And I'm absolutely convinced that at least all but one, and maybe all of these treatise writers, never looked at it.
Yeah.
It was too hard. They couldn't find it either. I only found it because of Google Books.
Yeah. Yeah.
I have to say, Google's my favorite company in the history of the world because they've
Okay.
given me stuff and never
Yeah.
asked for anything in return.
Okay. So that's validation for
All
Jan
these
Mehta.
obscure old things that I find in Google Books, I love
Yeah.
it.
Yeah. Well, very innovative company, and engineers behind it. So one more point that I just wanted to get back to, and then we can just conclude, is so in the presentations that were made, there was also discussion of Google's new access points like circle to search and Google Lens. And does that have to be compatible? I mean, that kind of has to be available to other searches. Is that some discussion that you remember?
Well, if it's an access point that Google creates, like Google Lens,
Yeah,
no, Google controls that. But if
yeah,
it's an access point that somebody else controls, then that has to be available. And one of the issues that still kind of up in the air
yeah,
is whether the contracting going forward or the deal making, if it's not
hmm,
even in a contract, has to
yeah,
be access point by access point and or what. So like 10 days ago, Mozilla filed a brief saying we want to be allowed to enter into an omnibus contract. That's
okay,
not a word I
yeah,
understood in this context, so I looked at the filing and it said
yeah,
we want to enter into one contract. It
okay,
says that we will make somebody, it's going to be Google, the default in every instance of our browser in any configuration, in any context.
yeah,
We want that as an option.
okay,
Maybe we won't take it, but we want it to be an option. And so Judge Mehta will have seen that. I'm not sure he's accepted the brief, but he will know what it says, even if he doesn't accept it.
yeah,
And he will think on that question, which he should,
yeah,
and probably include in the decree the answer to the question, can you do that? And the answer should be yes. If that's the way that Mozilla wants to do business, why shouldn't it be allowed to do business that way?
yeah.
But it doesn't have to do business that way. So what Judge Mehta would probably write is that Google can't insist on it.
But I thought Mozilla wanted Google as the exclusive.
Yes, but
So
it's got to be Mozilla's choice. And
yeah, but why is Mozilla filing that in the court? Isn't that
because
something that?
they don't want Judge Mehta to issue an order that causes Google to say, we're not allowed to enter into the contract you want us to
Oh,
enter into.
okay.
We have to enter into 112 separate contracts.
I see. So this is wow. So this is like great win for Google. I mean, it's like support for Google saying we want Google on every every kind of access point, correct?
Well, they do, but they want the option. They want to make sure that a year from now, when they're
Hmm.
negotiating the next contract, I don't know what the
Yeah,
actual date is, but let's say it's a year
yeah,
from now,
yeah.
they know what
That
the
they can.
parameters are.
Yeah,
And
yeah,
they want the option of one simple contract that
yeah,
covers everything.
yeah,
Microsoft's also filing stuff saying you shouldn't let them do this, you shouldn't let them do that. And
yeah,
I don't remember what this and that are,
yeah,
but I was surprised that people kept filing briefs. The latest, Microsoft's is just last week. It should have stopped, but
yeah.
it hasn't.
Well, I think because of AI, like the everything is heated up, right? In this space. So they're just going to compete to the
Yeah. And of course, immediately after we do get a final judgment,
yeah.
we go
Then
to the appeal phase.
yeah.
And that's when the real fun starts.
That would be the next interesting part.
I've already written my brief.
Oh, already.
Well, I've had a lot of time.
Yeah.
The remedy hearing was over at the around June 1st. I don't remember the exact dates.
Yeah.
And then I started the next day writing my appeal brief.
Yeah.
I I didn't know what the remedy was going to be at that point. So some of the stuff I wrote I threw away because he didn't order that. I can't complain about it.
Yeah.
But all the stuff I wrote about the liability is still good.
Yeah.
If Google appeals, which is almost a sure thing,
Yeah.
it's almost a sure thing that they'll appeal on liability. Winning on liability is everything.
Yeah.
But they will appeal on liability, and they have grounds.
Yeah.
I think they
So,
have good grounds.
yeah, because if there's no liability, there's no remedy, right?
That's right. And if there's
Yes.
no liability here, then all the rest of the world hears that.
Yeah.
It sends a message.
So, are you going to tell us your brief already, or that would be for the next podcast?
Well, it would take a long time and be boring if I went through all the detail in
Yeah.
my brief, but I'll give
Yeah.
you a little bit of the big picture.
Okay.
Leaving a lot on the cutting room floor that I think is important. My brief says that Judge Mehta made two crucial legal errors.
Okay.
And he made one of them even before the trial. So, in civil litigation, there's always a round before the trial. There may not be a trial, but there's
Yeah.
always a round before the trial.
Okay.
Frequently, two rounds before the trial. And so, one of those rounds is a motion to dismiss, and one of those grounds is a motion for summary judgment.
Mm-hmm.
And of course, the government won both of those rounds, or there wouldn't have been a trial.
Yeah.
In the summary judgment round, the key argument that Judge Mehta rejected was Google's contention that the government had to show that its conduct wasn't competition on the merits. And Judge Mehta said, no, they don't have to show that. And I think that was error, and I think it's reversible error.
Okay.
Antitrust law is concerned about the process of competition, not the outcome of the process. Monopoly's not illegal, but
Yeah.
getting a monopoly, that can be illegal under some circumstances. But
Mm-hmm.
what circumstances? I say if you get a monopoly through competition on the merits, that's legal. If
Yeah.
you get a monopoly other than through competition on the merits, that's not legal. And I think a
Yeah.
lot of cases support that view of the law. It doesn't make everything simple, by no means.
Yeah.
But I think that's what the law is. I think that's pretty clearly what the Microsoft decision said, although it could have been clearer. Judge Mehta, I'm guessing, took the view that exclusive dealing is never competition on the merit. And that's just wrong. There's cases that effectively say that it is, and it certainly is if the distributors want to deal exclusively and you
Yeah.
just make the best offer. Making the best offer is exactly what we mean by competition on the merits.
Yeah.
And there are cases like this already been decided that should have been precedent that convinced Judge Mehta, but he just couldn't get around that this was exclusive dealing. Exclusive dealing is bad.
Yeah.
The second error, I think, was jumping to the conclusion that exclusive dealing necessarily produces an anti competitive effect. In legal terms, the issue here is what's called causation.
Yeah.
So Judge Mehta looks out on the world and he sees that Google's rivals didn't get distribution and Google did. And he says, well, Google says that the government has to prove that the exclusive dealing caused that. And he says, no, they don't. They don't have to prove that. And I think they did. I think it's exactly what they had to prove. And if
Mm-hmm.
they didn't have to prove that, and still failing to prove it means they're not entitled to any of these behavioral remedies that are what could really matter here. Google's willing to not deal exclusively because it agrees with me that it doesn't need to deal exclusively. Contracts don't
Yeah.
have to say you must deal only with me because they're going to deal only with Google. So I think that these are not fine points. They're fundamental points of law. Judge Mehta made errors on both of them. And if Google argues these points in the Court of Appeals and draws a decent panel, then you never know what you're going to get. Then the odds are heavily in their favor that they will win on liability in the Court of Appeals.
Wow.
They have to be in the DC Circuit. That's where the case is.
Mm-hmm.
So we know what the potential judges on the panel are, and like Google's chances with these judges.
Is that correct?
Nothing's a sure thing,
Yeah.
but
Yeah.
I like their chances.
Wow.
And I know they've got competent counsel. So I think this case is going to go on for more than another year. And In the end, there's a good chance that Google will win.
Yeah, very interesting. So there's a lot more we can expect to happen and to Google's benefit.
Yeah. It's possible the case will go very fast at this point.
Yeah,
So the big question is, does Google have to do more than it's already done on the remedies? Does it have to start sharing the data pending appeal?
yeah,
Google's going to ask Judge Mehta to rule that it doesn't have to do anything pending appeal. And he
yeah,
might.
yeah.
And if he
Sure.
rules that, the case will be on the usual slow track and take more than a year for the appeal. If he doesn't rule that, then Google will ask the Court of Appeals to rule that. And it might. But Google has had bad luck with these stays. In the Epic case, it didn't get the stay.
Yeah.
And although the district judge hasn't signed off on the settlement, Google was pushed to settle that case on terms that were substantially similar to what the district court was ordering. And because it just ran out of time, it had to implement the remedy pending appeal.
And things went another way for Apple, right? Apple was won that
No,
case.
Apple's totally up in the air now.
Is it?
Because the district judge got mad at Apple and issued an order that prohibits them from collecting any money in the App Store.
Oh.
And that's on appeal.
Well, very interesting. But I have one more question. In terms of, Google has been, and as you mentioned, this, what is it, case that has been cited by Google is the Microsoft case on the Internet Explorer and how that
Yes.
was thrown out. What was that case and what is the bearing to Google? Is that something that they can benefit from? Does that contribute in any way to what you're saying?
Yes. Absolutely. I think it's relevant on many points,
Yeah.
but they're basic points of law, like whether you have to prove departure from competition on the merits. The case can be read both ways, but I think it basically says yes, you have to prove that.
Okay.
On what you have to prove to be entitled to these robust behavioral remedies, it speaks to that question. Um,
Okay.
as Judge Mehta recognizes, I think he misreads it. I think he misreads the next round in the Court of Appeals in that case. Massachusetts versus Microsoft's the name of the case.
Yeah.
Because there was a question there about sharing source code, whether that was a
Yeah.
structural remedy, whether
Yeah.
the states were entitled to it. The Court of
Mhm.
Appeals said it is a structural remedy and the states are not entitled to it. The data sharing is very similar. So I think a lot of things in the Microsoft decision are on point, and it is certainly the controlling precedent. There's no doubt about that.
Yeah.
I think, I don't remember exactly what he said, but Judge Mehta made comments during the trial about how much time he spent reading that decision.
Yeah.
And I have too. We all have. We keep going back to it. In some ways, I think it's a difficult decision to understand
Mm,
because it was written by a lot of different people.
I
And the
see.
sections are not all completely consistent,
Yeah.
particularly in use of language. Of course, they're not going to be when they're written by different people. So, what one section seems clearly to say, another section may seem inconsistent a little bit with. Um,
Okay.
this I don't know literally how many authors this had, but it is more than the usual case because
Yeah.
this case was not decided by three-judge panel, it was decided by the en banc court. I think that was in fact only 5 or 6 judges because the rest didn't take part, presumably because of recusal.
Yeah.
But it's pretty obvious they divided it up.
Yeah.
You normally would in something this big a project. And then they had to try to make it fit together, but that's a problem. I don't know how many committee drafting projects you've been involved in, buddy, it's a problem. The
Yeah.
sections never fit together.
Right. 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 Okay. So, and of course, the last question that I would ask you is that given that we have the president, does that have any bearing on the politics of it? I mean, we've talked about the economics and how, the legality and how the economics kind of favors Google in terms of its dominance. Is there any kind of overall political effect that, why bother big tech?
And no, 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 no. It's the other way around.
Okay.
It's obvious that the current president doesn't like Google. And
Okay.
And the reason is obvious and well known too. It
Oh,
is
okay.
because Google was accused by conservatives of suppressing conservative voices,
I see.
something on which apparently there is a tiny bit of confirmatory evidence, but I'm pretty sure it didn't happen. But the truth is irrelevant.
Yeah.
And the morning that the remedy hearing began, the number two person in the Department of Justice made a highly political statement that talked about suppressing conservative speech on why something needed to be done about this Google monopoly,
Okay.
as if this was a case to do something about the Google monopoly. It certainly was not.
Okay.
It's right there
Yeah.
that this is all about something it's not about at all.
Right. Okay. But maybe that wasn't a great question. But anyway, I think fascinating discussion and always so good to have you and shed light on this very important case, and that there is going to be more action, and means that I'll get a chance to talk to you again. So very grateful for you and all your insights in the case.
Okay, I don't think it's going to the Supreme Court, but we could have another year.
Yeah, okay. Well, thank you very much. Any other comments, lasting kind of thoughts?
Well, I like historical tidbits. I was musing over the argument that people make all the time that antitrust can't cope with big tech. And they make some good arguments. I think this argument could have been made in 1925, 100 years ago, just the way it's being made today,
Yeah,
based on the Standard Oil case. Everybody knows that there was a Standard Oil case. A few people know what it was about,
yeah,
but it was about kerosene, a dead product. And it's been a dead product for 100 years.
yeah,
But it was a really important product in the late 19th century when the events took place that the case was really about. It was fighting the last war. People say that's what antitrust does. Well, antitrust has always done that.
yeah,
And yet the Standard Oil case goes down as the greatest victory in the history of antitrust. But kerosene was rapidly dying out as an illuminating fuel because
yeah,
electricity was a thing.
yeah,
And gasoline was what the petroleum industry became all about. When the case, I looked this up because
yeah,
you can on Google.
yeah.
When the case was filed, there were 100,000 registered motor vehicles in the country. That was in the year 1906.
Okay.
By 1913, there were a million,
Yeah,
and by 1921, there were 10 million. Cars, trucks, and buses became important. Gasoline became the petroleum industry, and kerosene was dead.
yeah,
Yet oil lived on. Google will probably live on too, even if old fashioned search dies.
yeah,
Microsoft has lived on.
yes,
So these cases mean something.
yeah,
And you never know, even 100 years later, exactly what they meant.
correct.
People are still fighting over what the effect of breaking up AT&T was. We
Right.
don't know. We'll never know. But
Yes,
there was an effect.
yeah, okay. Well, thank you for sharing that historical insight. And again, thank you very much for your time and look forward to seeing more of you. Thank you very much.
You're welcome.
Bye.
Goodbye.